That's all the proof we have, Judge.
All right, I will hear arguments from both sides.
And Mr. Vandenburg wanted to LT.
All right, fine, he has that right. You can do it podium right here.
Your Honor, I'm grateful that I have an opportunity to convey my thoughts, not only to you, Your Honor, but to my family, my friends, and Ms. Lackey. I am here before the court, saddened, scared, ashamed, and remorseful for the crimes that I have been convicted of. Your Honor and everyone involved, I am sorry. Ms. Lackey, I am deeply sorry. It seems inadequate to try to explain how this all happened. I go over and over this in my mind and try to replay what could have been done to prevent the events of that night. I'm ashamed of myself and that I was so irresponsible with alcohol, which led to something tragic. I've worked so hard for so many years to reach my goal of getting a scholarship and playing in the SEC, going to Vanderbilt, and getting a world-class education. My life and the lives of all of those around me, including Ms. Lackey, seemed to be a dream at that time. I was living out my dream, and in an instant, it all changed. I didn't know anyone in Nashville except my mentors on the football team that I had just met, being that I had just moved a few weeks prior from California, over 2,000 miles away. I was an inexperienced drinker when I arrived at Vanderbilt just a few weeks prior, still not of legal drinking age. I was drinking all that day with my football mentors. Then we went to another party and drank, and then to the Tin Roof Bar, having drinks supplied to us. I wanted to be accepted and fit in with my new environment. My family was very far away. My football family was my family. I went out that night with my teammates, Miss Lackey meeting me at the Tin Roof, doing what we had done before. But instead of having a fun night, it turned into something that spiraled out of control, and we were all living a nightmare that I don't wish anyone to go through. My judgment was severely impaired, and I'm sad for everybody involved. I was very intoxicated that day, consuming nearly 40 alcoholic drinks. Several witnesses said that I was extremely intoxicated, speaking gibberish, not making sense. Never could I have imagined this to happen. I did not intend for this to happen or for anyone to be harmed. I caused people harm, including my family and friends. I was raised better than this. And I have disappointed many people. I've ruined not only my future because I was drunk and failed to act, but the futures of others. I'm scared because as a young man, I do not know what the future holds for me. I never and could never have imagined that I would be in a situation like I am today. That was not my intention coming out here. I don't know much about the court process other than what I've been in, and I know that I never want to be involved with it again. I've always tried to be the best person I could be, helping those that needed help. I volunteered at my Catholic high school, I did mission work, I tutored young children, and I coached football youth teams. But on June the 23rd, 2013, I let everyone down and many lives were destroyed. After the incident, I told police what I thought might have happened. In my statement, you can see that I did not even know Mr. Banks, Mr. Beatty, or Mr. McKenzie because I had just arrived on campus. I could not identify who did or said what. I did give the police my phone and offered to try and find any potential evidence that was on my phone. Offered to tell Miss Lackey what I thought had happened. I wanted to talk to Miss Lackey. And try to tell her what might have happened or what I thought happened. but the detectives told me not to contact her, so I didn't. I tried to assist in any way that I could and not interfere with their investigation. I hope through prayer that I am forgiven and God provides everyone the strength to get through this tragic event. I wish that I could replace the person that I was on June 23rd, 2013 with the person that I am today. The person today does not drink alcohol. My thoughts are clear, I am responsible, and I think of others. I rely on my faith. The man I am today would have had a different outcome. I can be a positive person to others, and I have learned from this devastating event. Once I have served my sentence, I can see myself as a positive role model and teach our youth about my experience. I want to help my younger brothers who are losing their eyesight and will eventually go blind due to a degenerative disorder and be there for them in the future. I'm confident in the future I'll be able to redeem myself. I understand, Your Honor, that you can sentence me to many years in prison, and I pray that you can see that I am truly sorry for the actions of that night. I'm a good person, and I ask for your mercy when you sentence me. Please, Your Honor, thank you. May God continue to bless you, Miss Lackey, and everybody involved.
All right, argument.
Judge, we do have a transcription talking about Mr. Fenzio.
All right.
For Mr. Finley, and letter from Mr. Garland, March 27, 2014, regarding that evidence, and then the transcript of Mrs. Becky's statement there to Mr. President.
All right. All right, Ms. Jones.
Thank you, Your Honor. The state has submitted a notice of enhancement factors. Those include that the defendant has a previous history of criminal behavior. Part of the pre-sentence report includes, while possibly considered to be minor, he was convicted of disorderly conduct while he was out on bond pending the retrial of this case. The court has heard ample evidence relating to Mr. Vandenburg's participation in directing others and himself destroying evidence in this case, beginning with the condoms that he got rid of, also including the devices, cell phones, and laptops, and his attempts to get rid of the videos that he took and sent to his friends in California. The court can also consider the testimony related to any attempts by Mr. Vandenburg to have previously drugged any other persons, but there was also testimony in these proceedings related to the symptoms of this victim, related to her extreme unconsciousness, the description of the blue drink, the California iced tea, the fact that witnesses testified that she was struck on her buttocks multiple times with absolutely no response and struck so hard that it caused bruises. And at the same time that Mr. Vandenburg was striking her, he was reassuring his co-defendants that she was not going to wake up. There were also several incidents the court can consider as perjury on behalf of Mr. Vandenburg. He testified at a suppression hearing regarding the circumstances of his police interview, in which Your Honor heard testimony from both Lieutenant, now Captain Donnie Harville, as well as Detective Jason Mayo, that directly contradicted that any of those circumstances were possible. In another hearing, he also gave testimony that he had no memory of what happened, which was contradicted by his own interview with the police. The second factor that the state has submitted is that he was a leader in the commission of an offense. Mr. Vandenburg asked his three co-defendants to assist him in getting the unconscious victim into the dorm room that night. Your Honor has heard the videos. You've heard Mr. Vandenburg's voice on the video telling Brandon Banks to squeeze the water bottle. and you've heard the testimony of Jaboria McKenzie and Mr. Brandon Vandenburg's foul language that need not be repeated here today, encouraging everyone in the room to rape the victim that day. He also passed out condoms, he took videos, sent them to football players at Vanderbilt as well as his friends in California. The next factor the state submits is that the personal injuries to the victim were great. Typically, the courts consider physical harm, but our courts have broadly defined that harm to also include severe emotional injuries and psychological scarring. And Your Honor, there's a court case, State v. Williams, it's at 920 Southwest 2nd, 247, that specifically states that this court can consider the severe emotional injuries and the emotional impact to the victim for this factor. And I have a copy of that case to submit as well as...
Actually, I'm aware of that. But you can submit it.
The state has submitted a letter from her counselor at Vanderbilt who described the traumatic emotional impact that the rape had on the victim in the months following this attack. Additionally, the state submitted a letter and CV from the victim's clinical psychologist. And she describes specifically that a victim who was raped while unconscious suffers from a more complex trauma than other rape victims because a person's body still has memory of that trauma. She further details the severe emotional effects on this victim that are those of post-traumatic stress disorder. And she details that she believes that she will need continued therapy and support for a very long time. Another professor at Vanderbilt submitted a letter to Your Honor who compared the person she knew before this rape to the one now as a person who was totally broken. The state also submits that the factor that this act was committed to gratify the defendant's desire for pleasure or excitement, that factor applies as to counts 1 through 5 and 8. The motivation for rape can be something other than pleasure. It can be motivated by acts of brutality, revenge, punishment, or intimidation. Your Honor heard his testimony throughout these proceedings regarding Mr. Vandenburg's purpose of sexual gratification. Mr. McKenzie testified to his acts that he went to and in his attempts to obtain an erection that night, including touching himself, pouring water on him, and going through pornographic websites. And while he could have a purpose other than sexual gratification, the only purpose that could be, the state submits, also would apply to the next factor of that this was done for exceptional cruelty. For Mr. Vandenburg to orchestrate a 30-minute gang rape of strangers, of someone that he is dating, to record that and send it out to fellow students as well as his friends back in California can be described as nothing but cruel. The testimony in this case also includes that she had vomited. She was motionless, non-responsive, even after a 30-minute attack where she was raped, slapped, and urinated on. There's also testimony that potentially she could have been drugged. There is case law in Tennessee that when a person leaves someone in a state and does not obtain medical attention for them, that can be considered for exceptional cruelty as an enhancement factor. The specific case is State v. Pohl, 945 Southwest 3rd, 93. But Your Honor, what the state feels distinguishes this case and should distinguish the sentence imposed for Mr. Vandenburg is that he abused a position of trust. And the state concedes and understands that typically a dating relationship or a husband-wife relationship would not be that would fall under this enhancement factor. However, the case law specifically states that for the application of this trust factor, that the court must look at the nature of the relationship, of whether the defendant formally or informally stood in a position that promoted confidence, reliability, or faith. And that if such a relationship of private trust is shown, it is the exploitation of that vulnerability due to the trust and the exploitation to achieve a criminal purpose for which the law deems more blameworthy. Again, the Supreme Court in Tennessee, State v. Kissinger, has defined that the court is not to look at specifically the title of the relationship, but the court should look to that nature, look to the trust, and determine whether or not that trust was used by the perpetrator to commit the offense. The evidence before you is that Brandon Vandenburg was in a position of trust with the victim in this case, and that he did exploit that private trust in order to commit these crimes against her. That proof begins with her testimony and her friend's testimony that when they went to the Tin Roof Bar that night, they left her with someone that they trusted. That testimony also begins with the messages that Mr. Vandenburg sent. He sent messages just hours before the attack to his friend Joseph Quinzio in California saying, "I'm going to make sure I F tonight." And Mr. Quinzio responded to him, "Call me during." And hours later, after the victim who was dating him, who trusted him, she becomes completely unconscious. However she becomes unconscious, he takes her to the Gillette dorm. And Your Honor is very familiar with the attack that ensues after that, but just as he told Mr. Quinzio, he did call him during. He sent him messages telling him to FaceTime. He recorded the rape of 3 strangers that he recruited and sent them to his friends. And Your Honor heard his voice laughing while this was happening. But what strikes to the legal reason, the legal definition that shows even more so how he exploited that trust are the actions of Mr. Vandenburg afterwards. That next day he begins sending messages to the victim, telling her about her bad behavior, that she had done something wrong, telling her how he had to take care of her and he was upset, explaining to her how she had embarrassed herself, and she explained how terrible that made her feel. She was embarrassed, she was ashamed, and she didn't understand how that could have happened because she had no memory of it. And Mr. Vandenburg said that he did that in an attempt to get her, number one, to make sure she doesn't remember what happened, but also he begins to get her to come back over to have sex with him so he can cover up the evidence even more. Miss Lackey and her friend both testified that sometime during that day he started being extremely nice to her, overly nice to her. And she did go back to his dorm room that day. This man, whose character letters describe him as such a genuine, wonderful, kind man, used those abilities to manipulate her into coming to his dorm room that day, to manipulate her into having sex with him. That shows that she trusted him. That shows that he had every ability to exploit that trust. Mr. Vandenburg told the police that when he was talking to his co-defendants, they said, "You need to have sex with her to try to cover up like whatever happened." happened. And so the next day I had her come over. I don't know if she told you that or not. We ended up having sex unprotected, and that was that. And again, the state submits that none of this could have happened had the victim not trusted Mr. Vandenburg in order to get her into this situation to have these acts committed upon her. And it is the abuse and exploitation of that trust that distinguishes this. It also distinguishes Mr. Vandenburg from his 3 co-defendants. He was the one that had her trust. He was the one that used that to get her there. And when that is done to achieve this criminal purpose, the law states that it supports an enhanced sentence. Elizabeth Lackey was 21 years old when Brandon Vandenburg single-handedly changed her life forever. And his co-defendants would have never had the opportunity to commit their own violent sexual assault had he not created that opportunity. He used his position of trust, his ability to masquerade as a person described in those character letters to create that situation in which she was in the Gillette dorm that night. He was a leader in instigating and participating in this cruel attack on the victim, the result of which has left the victim with such devastating emotional injuries, of which she has described that it will never be possible for anyone to put into words how this has affected me. The humiliation, the pain, the isolation, being reduced to nothing but a piece of flesh right before your eyes. It does something to you that is truly impossible to describe. The state asked this court to distinguish these actions by Mr. Vandenburg by imposing an enhanced sentence that is significantly more than the minimum sentence. And Your Honor, the state would like to submit 2 cases related to the position of trust that support the state's contention.
Are you talking about State v. Scott as one?
Actually, State v. Kissinger that just defines the relationship and the position of trust legal definition in a Supreme Court case. Also State v. Jackson, which is 946 Southwest 2nd, 329. Specifically in that case, it describes an analogous fact scenario where it was a live-in boyfriend and girlfriend, and that the boyfriend had decided to harm his girlfriend before they went to bed that night. And because he had made that decision before, he exploited her trust to get her in a position where he could harm her. And the state submits that is analogous to what Mr. Vandenburg did in this situation.
Well, I will accept your cases. I have before me a State v. Scott, which also has the definition of trust. So I'm very well aware of that. All right?
Sure, thank you.
All right. Ms. Reagan or Ms. Perez, whichever.
Judge, we submitted a sentencing memorandum in this matter. We would, of course, rely upon the arguments in the sentencing memorandum.
Right, and I have read that sentencing memorandum.
I think, Your Honor, in this case, Brandon Vandenburg, when he came to Vanderbilt, was 19 years old. Turned 20 years old shortly after arriving on campus. Had never been away from home for any length of time. Came all the way across the country to attend Vanderbilt University because he wanted a good academic education. What happened after that? You know, there is a tragedy on so many fronts. What happened to the victim should never have happened to her, should never happen to anyone. And I think you've heard, Your Honor, from people that know Brandon Vandenburg and have known him for most of all of his life, that that is not the Brandon Vandenburg they know. That this was not in character for Brandon Vandenburg. In sentencing considerations say that the sentence is to be the least severe measure necessary to achieve the purposes for which the sentence is imposed. And we're not here talking today about whether or not Mr. Vandenburg is going to be on probation. We're not talking about whether he's going to serve 6 months. We're talking about, at the very least, he is going to be serving 15 years in the state penitentiary. At the very least, at 100%. That is a severe measure in and of itself. And we submit that that is the least severe measure necessary. You've heard the proof here today from people that know Mr. Vandenburg that he is not a danger to the community. It is not necessary to protect the public from further crimes. His potential for rehabilitation is great. And a sentence of longer than 15 years would be much more than is necessary in this case. This is a young man who has never spent any considerable time, even in jail, except for the time that he spent incarcerated over this case. He has never spent time in the state penitentiary. He will be branded a sex offender. We know how those people are treated in prison. It's going to be 15 years of the most severe punishment you can imagine. Not from the state, but from the other inmates. He's going to be required, and has already done so, he's going to be required to register as a sex offender for the rest of his life. He is going to be on lifetime community supervision whenever he gets out from whatever sentence Your Honor imposes. All of this together, Your Honor, please, it's clear that this 15 years, if you sentence him to 15 years, that is a severe measure, and it is the least severe measure under the sentencing statute. And I won't go through all the letters that we've submitted in support of our sentencing memorandum and in support of Mr. Vandenburg. But there were well over 30 people. Vandenburg, what did I say? I'm sorry, Mr. Vandenburg. But there are over 30 people that wrote letters. That is not just one or two people that he could have fooled or tricked somehow. You might fool one or two people, but you don't fool 30 or 40 people that have known you all your life. With regard to mitigating factors, Your Honor, please. Mr. Vandenburg's criminal conduct, and one thing I want to make clear, Judge, is in the election of offenses in this case, the offenses for which Mr. Vandenburg was being held criminally responsible for, each and every one of those are acts of someone else, not of Mr. Vandenburg. They were what Mr. Beatty did or what Mr. Banks did, and not what Mr. Vandenburg may have done. And Mr. Beatty, the man who the state says in their election of offenses is the one who performed these acts. Mr. Beatty, the one who raped her. Mr. Beatty, the one who urinated on her. Mr. Beatty, who sat upon her face with his genitals. Mr. Beatty received a sentence of 15 years in this case. Mr. Vandenburg did not do any of those things. He should not be sentenced to more than Mr. Beatty was. Mr. Vandenburg's own conduct, and sentencing is an individualized determination, but Mr. Vandenburg's own conduct did not cause or threaten serious bodily injury. We know from the proof at trial that the victim said that she didn't even know anything had happened to her the next day. There was maybe some bruising, and I'm not trying to minimize what happened to her at all. But as far as serious bodily injury, there was none. And we've named a number of others in there, but I think a significant one is that he assisted the authorities in uncovering offenses committed by other persons or in detecting or apprehending another person, Mr. Vandenburg, and his statement was played at the trial. He gave a full statement to the officers. He told them what happened. He gave them his phone. He told them who else was involved. He told them that he had sent videos out. He assisted the authorities in locating and recovering property and persons involved in the crimes. And with regard to his intoxication that night, we know from the proof there are a number of witnesses, and Joey Quinzio in particular, who said that when he talked with Mr. Vandenburg at the time that Mr. Vandenburg was speaking gibberish, wasn't making any sense. He was very intoxicated. And we submit that that would fit under the mitigating factor number 7, that he committed the offense under such unusual circumstances that it's unlikely that the sustained intent to violate the law motivated the criminal conduct. There's proof from his statement that he did not know at the time what exactly was going on. And you can see in the text message to Mr. Quinzio, he's saying, can you send me those videos back so I can see what's in them? I don't know what's in them. I mean, it's obvious from the proof that he was very intoxicated. And that is something that may not an unusual circumstance in his life, based upon what we know from the people that know him, that he was not a drinker. And he has expressed remorse for his actions. He expressed remorse for his actions here today. He told the police when he gave him his statement initially, I wish I had done something to stop it. I wish that it had not happened. So he has done that. Prior to the instant offense, he had no criminal convictions. Since then, he has had this incident at the school, which ended up in a plea to an offense, uttering offensive words, the very lowest form of misdemeanor that he could have. But certainly, it was not, he had no prior criminal offenses before this incident. And, Tennessee Code Annotated 4035-103 and 4035-210 allow you to consider good character and potential for rehabilitation as mitigating factors. And the letters that we have submitted evidence that he is a person of good character. None of us is as bad as our worst day. Everybody does things that they wish they had not done. And I'm sure Mr. Vandenburg wishes that none of this had ever happened. He wishes that he had done something more to help the victim that night. But because of the circumstances that existed at that time, because he was so intoxicated, because this was something that he was not used to being involved in, that it was something that happened that he did not want to happen. And that's what he told the police at that time. With regard to this abuse of a position of private trust, and we cited the case of State versus Scott that Your Honor was talking about in her memorandum. And in that case, even a relationship as close as a husband and wife does not warrant the application of that factor. And the cases say that applying this to the mere existence of a relationship between competent adults, if we applied that in every case, it would result in an overbroad application of that factor. And the state is trying to have it both ways, Judge. At the trial today here, they say that there was this relationship that existed and they were very close and he abused his position of trust. But yet at the trial, the victim testified that they had seen each other only a few times. They knew each other. They had a relationship, but it was not the sort of relationship that warrants the application of that enhancing factor. And again, Your Honor, please, with regard to the other enhancing factors, these all deal with the actions of Mr. Beatty and Mr. Banks, what they did themselves. What Mr. Vandenburg did himself, he's held responsible for what they did. He did not do those things. And that's what the state's own election of offenses. And I know that Your Honor heard the proof at this trial. And regarding Mr. McKenzie's statements about what Mr. Vandenburg did or did not do, or what he said or did not say, we would simply ask the court to remember Mr. McKenzie's 4 different statements that he gave in which he said nothing about any of this until the very last statement. He had many inconsistent statements about what exactly it was that happened. And the state keeps bringing up this theory that somehow the victim was drugged in this case, when they know, based upon their own testing, their own scientific tests, that there was no evidence of that whatsoever in any of those. And today the state made reference again that the other 3 would not have had an opportunity to commit this kind of act had it not been for Mr. Vandenburg, when the state knows themselves that Mr. Beatty, Mr. Banks, and Mr. McKenzie, the night before this happened, did virtually the same thing to another girl. They know that.
Please, that's not a true statement.
I've filed this many times. I have not ever allowed that in. I'm not allowing it in today.
What we're simply saying, Your Honor, please, is that just to say that this would never have happened had it not been for Mr. Vandenburg is simply not true. And the state knows that. But again, Your Honor, please, the sentencing statute says it's to be the least severe measure necessary, and there's not to be unjustified disparities between defendants. Mr. Vandenburg was convicted of of being criminally responsible for what Mr. Beatty and Mr. Banks did. Mr. Beatty, who committed these acts, was sentenced to 15 years. We submit, Your Honor, please, that given all the other attendant consequences of this conviction, that Mr. Vandenburg, the 15 years, is the least severe measure necessary. Thank you, Your Honor.
Thank you. John?
Judge, very, very briefly, the court has heard all the proof over 3 years now to arrive at this date for Mr. Vandenburg's individualized sentencing for what he did. And but for the things he did, Corey Beatty wouldn't be in prison for 15 years for what he did to a defenseless, helpless woman who trusted Brandon Vandenburg. Yes, individualized, but for his conduct. Counsel talks about what a draconian sentence, I'm not using his words, but that 15 years. Oh, and by the way, yes, he would have to check in once on his birthday for sex offender registry or whatever conditions they have about that, and lifetime supervision that goes with it. But the point is, the legislature in the state of Tennessee has determined that aggravated rape is one of, if not the most serious offenses short of murder, and deservedly so. 15 to 25 years, allowing a trial court, to use its sound discretion in determining a punishment for people who commit an aggravated rape. Mr. Vandenburg is convicted of 5 aggravated rapes, 2 aggravated sexual batteries, and the unlawful photography. Individualized sentencing for Mr. Vandenburg based upon the enhancement factors, and I'm not going to go through, but as far as mitigating factors, there are none based upon the proof. And with all due respect to the people who wrote letters, who came here today, are either unwilling or really don't know the true Brandon Vandenburg that I submit this court knows from the testimony, from the facts of this case, or that Miles Finley knows and knew. Mr. Vandenburg, with all due respect, I submit is justly deserving of enhanced punishment in the court's discretion, certainly, because of what he did. Not for what other people did, but for what he did, his conduct, his background, his involvement in this. And yes, the state even submits that he is a dangerous person. And the court can, if it so chooses, in its discretion, impose at least partial consecutive sentencing based on the case law as cited in the footnote. And I will just say, just for the sake of the Webb case, where the Supreme Court is considering and has ordered that this issue be briefed, to schedule for oral argument February of next year, so it's going to be some time. But I would submit that as of now, the court, based on the Bice case as well as the statute and the interpretation of that, it's an abuse of discretion standard, and the court can find that. And if there's anyone who would fit that standard based on this particular case, it would be Brandon Vandenburg. And with that, we do certainly leave it to Your Honor's sound discretion, but we echo the feelings and the sentiments of the victim in this case as to what he should receive.
All right, thank you all. As I have said before, this is one of the saddest cases that I have ever encountered in my many, many years in the system here. But, you know, be that as it may, I still have to just look at the evidence that was presented at trial, all of the motions that were heard, the sentencing hearing, pre-sentence report, the evidence at the sentencing hearing, principles of sentencing, the arguments of counsel, the nature of the criminal conduct involved here, as well as the enhancement and mitigating factors. As it has been stated previously, with respect to the range of punishment, the court finds that this is a range 1 case, and the parties have really stipulated to that. So that's not a major area of contention, or not an area of contention at all. The court does find that there are enhancement factors in this particular case. Pursuant to TCA 4035-114, one enhancement factor is that the court believes that the victim was particularly vulnerable because of her physical incapacity. Another enhancement factor the court believes is that the victim suffered psychological injuries as a result of this incident. Another factor is the court does believe that the defendant, abused a position of private trust. It has been pointed out, as stated in State v. Kissinger, and as the court cited State v. Scott, which was actually citing State v. Kissinger, that the court should look to see whether the offender formally or informally stood in a relationship to the victim that promoted confidence, reliability, and faith. And the court believes that that occurred in this particular case. So the court does believe that the defendant abused the position of private trust. Moreover, the court believes that the defendant was a leader in this particular offense. But for him, it would not have happened. And in particular, the court believes that he is the one who could stop this incident that destroyed so many lives here. In any event, the court also finds, with respect to mitigating factors, that there are several, that the defendant did not have any prior criminal convictions, and the defendant has a lot of family and community support. And he may be remorseful, it seems remorseful at least, but even having said that, the court believes that the enhancement factors outweigh the mitigating factors in this particular case. As such, with regard to counts 1 through 5, the court believes that the proper sentence is 17 years. With regard to counts 6 and 7, 9 years. And regard to count 8, 2 years, all of which will run concurrently with one another for a total effective sentence of 17 years. That will be the judgment of the court. Court be in recess.
All rise. A very brief recess.